This panel is what is computational law? And computational law, in a sense, is the essence of how we're going to make these DAOs work, how they'll be valid and enforceable, how they'll have some meaning in the economy and in the rest of the, kind of the legal and social infrastructures that exist as they are now. And it's also, this event is the Computational Law and Blockchain Festival. So we're going to try to backfill some of the computational law aspect of that now. And actually, was hoping we could start a little bit with you, Jameson, to set a little bit of context about legal hackers and and what we're all part of right now tonight.
Sure. So this is going to draw on some of the stuff that Tony mentioned before, and I apologize, I was late to the event tonight. I'm so thrilled to see all of you here because legal hackers is not just this local community; it's local communities all over the world. Since Legal Hackers started in 2012. It was formed by a number of students in Brooklyn, New York. It's grown to the largest grassroots legal innovation community in the world. We have 140 chapters. We have 60 additional chapters in formation. It's everywhere from Australia to Zimbabwe. We have 12 chapters forming right now in India. We have 5 chapters forming right now in Nigeria. We have over a dozen chapters in Brazil. And it's all growing. In fact, we've just about been doubling in size every year. So this is a growing movement. And our mission is to build an open culture for law. So like Creative Commons was to creativity, or Wikipedia was to open knowledge, or Khan Academy to open education, Legal Hackers wants to be for law and policy. The way that we achieve our mission is by bringing people together in local communities, breaking down silos between traditional professions, for example, the law, or technologists, artists, designers, entrepreneurs, government officials, and everyday people, in order to address pressing issues at the intersection of law and technology. And so this is a part of that. CLB is a part of that. But CLB is also something new. We started it last year, and the concept was, traditionally you have a large conference, and a large conference requires people to fly in from all over the world. It's very expensive to throw on. Maybe we could flip the idea on its head. Maybe we could create a template for the conference and then inspire people all around the world to host their own version. So we did it last year as an experiment. 37 nodes around the world hosted their own version. This year we have just about the same size, except the difference this year is that it was all self-organized. Last year we had to do a lot of work with the local nodes in order to get things off the ground. Some of them were super successful, some of them were smaller conversations, but still very dynamic. But this year, without much central organization at all, it just happened again, which I think shows the power of this format. And my hope is that this sort of model for creative problem solving could be applied in different formats. For example, things like data protection, or here we're doing blockchain regulation, but there are other core issues that we need to talk about. Something like climate justice, could we apply this model there? Other sustainable development goals. I know that's a priority for Tony and a lot of people in the room. So anyway, that's why we're here, that's what we're doing, that's what Legal Hackers is all about. Turn it back to you, Doug.
Thank you. On this panel is highlight a couple of sort of just over the horizon projects that are emerging now in computational law, and then engage everybody in a discussion about that, including how might we prototype or hack these things into existence in a way where they could be usable by everybody. One of them is, we touched on this a little in the last panel, how could there be a valid legal entity that was also completely automated, that was software based? So, for many years there's been concepts of, like C3PO or like an AI that would have legal personality. The reality right now is that there hasn't yet been an automated system that is also recognized as a legal entity. So one of the projects that we've been working on, more than one Computational Law and Blockchain Festival city, Silky and I were hacking on this in Brooklyn last weekend at the festival there, and we'll keep doing it, is rapid prototyping software that would do all the functions necessary with the Secretary of State in one or more of the states of the United States, necessary to form a corporation or an LLC and to maintain it. And then have a kind of a simple specification for that would be done in partnership with government partners, where they would agree that these are the data fields that you would need in the order, and how you would pay the $35 whatever fee. And then that component could be, and then some open source reference implementation of that standard could be made available and could become part of a broader container of software like a DAO, or it could be part of other types of software that small businesses or others could use. The other one that we're going to talk about in this panel is a really good example, is another key source of law. And the first thing many people think of is, judges and courts make these rules, and they can kind of gather dust on paper. How could that be made computational? And there's a very interesting hack that Jameson and others are going to delve in there. But to get started in the legal entity one, I wanted to ask first Oliver, if I could, to talk a little bit about what would it actually take for software to generate a legal entity. And it's partly because of this great work in years past with secretaries of state making software called Silver Flume that right now, kind of like manually with web forms can be the interface for a Secretary of State, such as in Nevada, to a lot of people to create a corporation. What would it take for software to be able to integrate and interoperate with that so that it would be valid and reliable?
Well, this process has actually been going on for some years. I was involved in a project back a decade ago to design some software that would do exactly that, which was the underpinning for the Silver Flume portal at the Nevada Secretary of State's office. Step back 1 second. If you're going to have a legally recognized entity that isn't a human, you have to have somewhere in the law that says, poof, there's an entity. A corporation is that, among other things. To incorporate, the corpus is the Latin body, so you incorporate, you embody. And the legislatures of the 50 states of the United States and of the governments in most places around the world say, if you follow this procedure and make this filing and this paperwork, poof, it's an entity. It's actually quite magical. We create these golems of these legal golems that can wander about. But to automate that process, you need two things really. One of them is that process with the legal folks who do that filing and poof, to that be automated. And actually that's occurred in many parts of the United States. Many secretaries of states, which are the offices in the United States that have to do that, have automated portals of various kinds, of various degrees. Most of them as yet don't have a direct interface of the kind you're talking about, which would allow a private party to kind of just do it. But even without that, many places you go in and you spend 20 minutes and a credit card and you've got the thing set. So to answer your direct question would be, what would it take to merge that? And it really would just be a protocol on the one side, the private side, and then a Secretary of State's office that it could interface with, some kind of interface setup. So,
such as an API?
The initials API might be there, yes, exactly. An API that would do that. Delaware actually has some of that, but they limit it to commercial enterprises rather than to the general public. The other piece you need is then you need the internal governance of the thing to be handled. And that internal governance is done in corporations with bylaws and things like that. Yes, the lawyers give you 50%, I'm telling you stuff you know. Also in things like partnerships or LLCs in the United States, an agreement will do that. And the next step really is to figure out the automation of that. And that's why I'm really excited to be part of this DAO experiment. Because a number of companies and DAOs are coming up with software that will provide this kind of new way of running things. And you've heard some mention of Vermont. I live in Vermont, I've been involved in things there. The Vermont law permits you to essentially make almost all of your agreement through software. So that if you've got a very thin paper layer that says a few things, including, and by the way, look to the software for that answer, you can embed almost all those rules and processes directly into software.
What's that you say? There's a new law in Vermont that enables this? What is that?
You know, it's always nice to be fed these lines. It's a law called the BBLLC law, which is blockchain-based LLC. It takes the LLC form and mutates it a bit to be more blockchain friendly. So on-chain governance is recognized, the ability to have people interact with it from outside in their own interest, as well as being members of the collective. There's a set of rules in there which if some of you want to talk to me afterward, I don't want to go in fully now, but which will make the form particularly well suited to things like DAOs, and so that's an opportunity in Vermont. And there are other states that are pushing this as well. I like Vermont, but we're not alone in this. But there are so you need to have that opportunity to have the automated agreement procedures and the interface with the government as the two pieces. I've been set up for that. Thank you.
You're welcome. Thank you for helping draft that legislation, so now we can hack the law properly. And so, so can you tell us, let's come at it now, not so much from the kind of existing earthly, corporate laws of states, but as a general counsel of Gnosis and really a player in the DAO and legal personality conversations happening around the globe now, how does it look from that perspective? And what are the drivers and inhibitors around having valid legal entity status like an LLC or corporation and a DAO?
I think what we need is for code to have legal personality. And we need this proof. Here is the DAO, basically, which right now you don't really have really any jurisdiction other than what I earlier said was at Malta, that they kind of getting to this stage. So I think generally, on one hand, I earlier in Brooklyn, I gave a short talk about like the international principle for DAOs, which basically should be some kind of private international law located principles which say that DAO have limited liability, because why even care about all these nation-state laws? But of course, this is kind of utopian at this point in time. And what we really need is for the legislator to get to a point where they recognize code as having a legal personality, or like some LLD, which is a limited liability DAO, being self-owning in itself. And of course you would need some kind of maybe an insurance fund, so if the DAO does something bad, to the rest to people, to have some consumer protection. But all of this is right now missing, but I think, I know regulators are actually working on that, and I do hope that something is going to come out of that. It's mainly small jurisdictions that are moving much faster, they're more agile than other jurisdictions. And I think we're just a bit early with our DAO ideas for there to be a perfect, suitable form. But I do like the Vermont law, and I want to say something about Vermont. Yesterday I was you told me that actually, I asked about whether you could have a robo-director, like a bot being the director, because I didn't want anyone else to be the director of the DAO. And Vermont nearly passed such a law, right? It just didn't pass. Would you mind talking a bit more about the robo-director?
The robo-director. You're giving us a little more credit than we deserve. There was a proposal for a law for giving a recognition through the corporate structure for a roboco, a robot corporation that would have allowed a corporation to essentially embody an artificial agency, which is what we were trying to generalize as the robot. We didn't quite, the law didn't pass, and I'm not quite sure we would have allowed a robot director. We would have allowed a robot member. We'll have to talk about that, because it might have worked. One thing I would, since I've got to my quick history thing, is, the modern corporation that we're used to really is less than 150 years old. The Delaware corporate law that we're used to and rely on came around 1900. And so it is, we think that's been there forever. It hasn't. It was an innovation then. It's time for the next innovation, and it's exciting to be part of that as we discover how to make that go forward. Here, here.
And the LLC is even more recent. And
Yeah,
so,
yeah.
the law evolves. And so part of the idea of this project that we'd like to engage your ideas on is, well, how could we also push from the existing laws as they are and the existing websites toward software automated systems? We think that we can do it. And so before I pass it to the next topic, which is judicial law, I just want to report forward from last weekend, the Computational and Blockchain Festival in Brooklyn. We actually had 3 projects, Ori, Ross, and Kurt, had all in various platforms created smart contracts that attempted to implement the blockchain-based LLC statute of Vermont, and they came at it somewhat different ways. And so, we've got some interesting prototype code there. We just need to look at the connectors at this point and kind of do some kind of data mapping almost with the fields and the sequence of events needed at some Secretary of State, and extend the implementation out to include that. So that's that project, and I think why don't we hear about the Judicial Project next, and then open it up to a conversation with everyone.
Sure. I'm gonna punt briefly because I'd like to set the table a little bit on computational law, and I'd like to, if she would, if Alexis would describe what the sort of things she's working on and the basics of that. I just want to put a question out there. If someone has already thought or read or written about this and has an answer, maybe when we pass the mic out to the crowd, I'd love to hear about it. So let's imagine a DAO. Let's imagine a DAO behaving badly. Let's imagine a DAO that violates Section 5 of the FTC, so unfair and deceptive trade practices. So it does something, it says it's going to do something and then does something else, or it does something that's unfair for some reason. There's some sort of surprise. Traditional remedies include a consent decree, hiring someone for compliance, changing internal practices, it might potentially fines. I'd love to know about the mechanics of each of those, particularly compliance plans and making changes. Would the FTC or some sort of regulatory agency have the right then to impose changes in the code of the DAO? And if so, how? And we can talk about that later, but these questions came into my mind about traditional enforcement mechanisms, people enforcement mechanisms, and how that maps onto this. So before we talk about how judges can write computational law, I'd love to start with what is computational law, and a company that's actually writing computational law. So Alexis, if you could share what you're working on.
Yeah, of course. Hi, I'm Alexis. I come from a little company from Singapore called Legalese. And the way we think about computational law is, well, if you think about it, law predates computer science, but a lot of things are run on software and programming today. But what if it was the other way around? And we suspect, in our hypothesis, is that law is slightly broken because we don't have a good way of reasoning about it, because it's a language problem. So even if we assume that, just without getting into multilingual contracts and translation and all of that, just take English, we don't always use the same words to mean the same things. We sometimes use different words to mean the same things. And just the idea of what does tabling something mean in the UK and in the US is completely different. They in fact mean the complete opposite things. And because lawyers have a language problem, we see them as kind of like the lost track of programmers. So to us, computational law means that you need to fix the language problem before you get into anything else. And the first thing is to taking inspiration from companies like Autodesk and Adobe and Intuit, is that you need to create a programming language that is able to express the semantics, the deontics, and the different sort of particularities of law in a programming language. So you need to create a domain-specific language for law. And law doesn't just mean the contracts, it means the laws, the regulations, the contracts, the business process logic, the quasi-legal and legal documentation that's involved in that, so that all of them have a common denominator and they can all talk to each other, because otherwise you're just talking at cross purposes. And once you have a way to programmatically represent law, with all those things combined, in a language, then you can compile them to natural languages, and that means that they can be backward compatible with existing legal systems, because your judges are still humans, and also they could be forward compatible with future legal systems, for example, on the blockchain, and then compiled to different language like Solidity and all of those things. And so this is a way to reason about laws. And the cool thing, not just because University is alpha law, is that you can now apply the battery of tools that programmers have at their disposal for the last 60, 70 years to law. Because 100 years ago, lawyers used typewriters to help with the work. Today, they use Microsoft Word. That's still using technology to help with the manual labor and not with the thinking. That's preposterous. So you could apply, if you have your laws in code, and in a way that represent all of those things, you could do like static analysis, you could do fuzzing, you could do unit testing, you could do compile time checking instead of runtime checking, which is actually called litigation. And sorry, I forgot to mention radical, so just go back and say radical a few more times, and I would be in theme today, so in line today. So that is how we see computational law at Legalese, and yeah, so does that answer that question?
I think it does. Yeah, so computational law, the way that we define it, so I'm with Codex, which is the Stanford Center for Legal Informatics. There's a professor there, Michael Genezareth, who came from the world of logic programming, and computational law for him is a formalization of law in machine-readable code. And it's all the things that... Whose alarm is that?
Oh, it's the law calling.
And so a lot of AI and law work these days, at least it gets the headlines, is about data-driven law, which is you have these giant corpora of legal texts, and how can you use natural language processing or other machine learning techniques in order to make sense of it, in order to, for example, make predictions about what a judge might do in the future. In fact, if you go back to Oliver Wendell Holmes, who's from the legal realist camp, he says that all of the law is prediction. That's what being a lawyer is. It's predicting what's going to happen in a case. Legal formalists were more on the computational law side of things. This is all logic. And they've fought, and the legal realists won in the real law, and the data-driven AI folks have won a lot in the AI and law side. But very recently, there has been a resurgence of interest in computational law, the formalization of law into machine-readable code, which fundamentally is a writing issue. If we're talking about forward-looking rather than backward-looking, you can take the IRS tax code, like TurboTax has done, and turn that into something machine-readable. But if we want to do this sensibly in the future, we should probably write the legislation and write the rules in a machine-readable way. And so the rules come from a number of different places. They come from the legislatures, they come from regulatory agencies, but they also come from judges who are going to be writing decisions. And so one of the things that we want to explore, and I believe there have been a number of folks who have explored this in the past, at least in a number of different formulations, but look at what it means to be a computational court. If you're writing judicial opinions to hand down precedent to others, how can you pass down a test of some sort so that the next court down can run its facts through that test to get some sort of results, and then compare cases across one another and build data structures based off of that. So that's something we're exploring right now. I don't have anything except for the challenge, which is if you have an idea for how to do this and how to do this right, or if you have great resources that we should look at for how to do this right, we're open to it, because we're really just exploring. And the idea is we just want to put some cases out there and see if judges, or if computer scientists and other creative people will make the conversion or come up with a structure for how it can be done, and then we can test it out, and then hopefully someday we'll have judges who implement that sort of stuff. So anyway, that's what we got.
Here. At MIT in the Media Lab, we've got a research portfolio which I run called law.MIT.edu. I encourage you to go there to learn more about sort of East Coast take on computational law. We've got a computational law course we do every year, and we're about to launch the MIT Computational Law Report, which will be sort of a combination of a journal where we can collect best of the thinking at Stanford Codex and from around the world. It'll also have a lot of rich media, podcasts and videos, so we can learn more about who's doing what. And maybe the coolest part is a data playground, where all these people doing data science on the laws that exist today, predictive analytics and graphs and very interesting stuff, could share their data, share like their Python notebook or their RStudio script and a little documentation to see if we can get reproducibility on this. So we can begin to use the scientific method as we begin to rely on data science as one of the factors of law, so that it can in fact be justifiably trustworthy. We're going to launch or announce the launch of the MIT Computational Law Report on April 27th. And Jameson will be joining us, and Tony.
Aren't you kind of like announcing it right now? You really just announced it.
No, this
was the announcement.
This is like Joe Biden talking about but that's when the actual announcement and the launch will be. And one of the things I wanted to tease out from you is this interesting hack that we want to explore that Gabe Tenenbaum suggested for how we can have judicial opinions express themselves in a machine-readable form. Right now, as we learned, it's written in like poetry. It's like natural language. It's like hardly parsable by a machine. What's this challenge that I think you and Gabe will take the lead on to render judicial opinions machine processable as well as lawyer readable?
Yeah, so we're going to take what we're going to do is we're going to take some existing opinions that are out there that we think are more readily computable, and we're going to put it out to a bunch of folks at the challenge, and then we're going to work together to see if we can come up with some prototypes for what it could look like. All the stuff that I just mentioned in my previous answer, that's really what we're trying to do, is put the challenge out there, give some samples, but then also seek really creative ideas for how this can be written better in the future. For example, like Justice Scalia, he called something once absurdity on stilts and poppycock and all this, which is colorful language but totally unnecessary for judicial opinion. So if you strip all that away to the logic and what's necessary, what does that look like, and to what extent can it be made computable? That's the challenge that we're putting out to folks.
How are you going to deal with folks that are scared of our world turning into 1984, where basically the language was standardized to make it in a way computer readable?
So at first we're not going to engage them. We're just putting it out there to see if it's possible, and we're going to see what it looks like, which isn't to say that there won't be consumer protections in there or human review of what happens. It's just a question of writing it better.
And if I want to say something that gives me great pleasure as a lawyer to say, let's really geek out for a moment. Because there's been this notion that law somehow wasn't already computable. It is. We've done some work that demonstrates that legal specification is a computational process using natural language as its rather cumbersome coding language. If you take legal rules, you can restate them into any number of different computational formalities. We've done this with contracting. Contracts turn out to be deterministic automata, and legislatures and constitutions turn out to be non-deterministic. But they already are computational. So really all we're doing is trying to figure out for the law what we did for so many other things over the last half century, which is figure out how to restate the alphabet or pictures or whatever it is into a machine computable language rather than into this natural language. And so your task is eminently doable. It's just you've got to work at it a while.
That's exactly right. And these sorts of problems have been worked on for a long time. In fact, hundreds of years, but most of the work has been done, say, the past 70 years. If you look on the CLB website, so legalhackers.org/CLB 2019, we have a resources page that includes a bunch of articles about this, some histories of legal informatics and computational law. Legalese put together an awesome R&D page, 70 years history of legal informatics that you guys should take a look at. A lot of work has already been done here, but I think that we're in a new stage, especially because of the blockchain community. I think this is a boon for computational law because you have so many developers who are grappling with governance issues, with on-chain issues, and I think that provides a really amazing pool of resources to tackle some of these challenging issues that have really been left in the lab, really been left in research centers that now we can tackle in the real world for real world problems. And I think a future that a lot of people in the room agree is going to come. So that's all I have to say on that.
So before we open up to questions, I want to be a little bit provocative. At the Media Lab, we obviously deal a lot with AI and have for a long time. Now with this new wave of AI, that's with all these new breakthroughs, it really caused a lot of internal discussion about, well, what would our role be in that, and what is the appropriate role for people going forward, including people in the back. Yeah, you. That's right. Yes, you in the back. Okay. Think of C3PO on one side. C3PO is driven by AI. It's an autonomous entity. Right? It can take actions without human review or approval. That's what it's supposed to do. That is one view of AI, and it's a view that's caused a lot of consternation. People wonder, what will be the role of people going forward? Are we going to be replaced by AI? And when the law is incorporated within AI, are we further alienated from decisions that will really impact our lives? So at the Media Lab, we don't talk much about AI per se anymore. We had some meetings, and the way we're coming at it is extended intelligence. So instead of C3PO, picture Iron Man. Something that extends the capabilities of people, and has some autonomous systems for sure, much automation, but fundamentally is human-centered technology that can allow us to, reach beyond what we would ever be capable of without the enhancement that's well tailored to our goals and our actions. As we drive the AI and are also transcendent and can transcend together with it. So with that thought in mind, I want to open up. It seems like, hey, everyone in the back, it sounds like you've got a lot to say. Do you have any questions? Yeah, you in the back, and also you in the middle and in the front.
Yeah, do I hand the mic out? Or
Do you mind?
No, I don't mind at all. As I hand the mic out, I'll say a great book that came out of MIT back in the 70s was Computer Power and Human Reason by Joseph Weizenbaum. He wrote the first chatbot, and he was really freaked out because his secretary developed a very close bond to the simple bot that he had developed. The bot was called Doctor. It was built on ELIZA, which is probably the one you guys have heard of. And he proposed that there should be certain things that we should not, as humans, we should not allow technology to do. So he set limits. He was also very anti-hacker, which is maybe not putting him on the right side of things. But recommended reading, at least for the provocation, and probably is something that regulators will adopt as they look at some of these systems. All right, handing the mic.
Actually, keep this one, because Daza has a mic.
Daza has a mic. Daza!
Who has a question?
Right here.
Okay, Phil Donahue, coming down the pump. Which one? Which one? You're right.
My name is Rob Dextrom. I used to run ICANN, which is a multi-stakeholder organization that does DNS coordination around the world. And what I would say is I've actually worked with this problem for about 25 years of contract modeling, and ICANN was this kind of special, case. And what's interesting in the DNS and the domain system of the internet as a whole is it transcends all the national legal regimes, which creates a tremendous amount of friction, and there have to be interfaces built to do that, specifically in the IP area. But I want to talk conceptually about the problem of legal contract modeling for a second. And that is, and it's very smart, you're trying to model these on a going forward basis because you try to create fresh, new, clean contracts. And what I'm going to submit to you is a problem, and I'd like to hear your thoughts on it, but what's the compiler? And the problem is the compiler is incredibly faulty. It's called the legal code and the legal system. And there's literally, I don't know how many millions of pages of legal code that itself is full of bugs. Now, in computer science, we're used to having compilers that have bugs, right? They often have bugs, but we can fix them. And it's fairly deterministic. And when I worked in Washington, I'd always say, guys, what we do here is sloppy code, okay? We do language code. And in Silicon Valley, they have to do really tight logical code. And then we're going to marry the two between them. And it was interesting to work in the ICANN context because the DNS of the internet has to run, so you have to work with brilliant engineers and lawyers, which is what you're doing. So I want to come back to it for a second. So the contract is a form of logic. You're expressing a form of logic. You'd like it to be consistent. You'd like it to be interpretable. And the problem is there's multiple compilers, right? State level, county, et cetera, international, that are faulty and contradict each other. So I just want to hear your thoughts about that as you work on this problem with codex, legalese, et cetera.
Yeah, so my quick response is it's a huge problem, and it's something that we're all going to have to think through. I think we're still at an early stage on a lot of this. I don't expect it to be done in the near term, like next 5, 10, 15, 20 years. I think if we're just starting to write the languages at this stage, there's still a lot of work to do. Yesterday we had a panel called Government as a Platform at the Future Law Conference at Stanford, and on the panel was, virtually on the panel, was Pia Waugh, who is the Executive Director of Innovation, is the Department of Finance Services and Innovation in New South Wales. She spent a lot of time thinking about this, but thinking about it holistically. So doing it from inside the government, reflecting the legislation as code so that someone could check against it, so that you could compile it against, in this case, New South Wales law. But that would take every state. States can hardly get their case law up online. Forget about all of their rules done, and forget about in a uniform standard. So it's a huge problem. It's going to take a while. That's why I think places like Singapore show a lot of promise, because there's a blessing from the top to do this sort of stuff. A lot of people are thinking really hard about that, and with that, I will pass it over to Alexis for more information.
Right.
I guess I just have one line to say is that, I mean, you mentioned sloppy code, but we're not competing with sloppy code right now because none of that is in code. We're competing with pseudocode. So we first need to move from pseudocode to at least sloppy code, and then we can perfect that better. So we're not trying to, so the law is unperfect, existing system sucks. That's why we're trying to build something better. It's not perfect, but it's not pseudocode, and I think that's a good start. Yeah.
Here. One other thought, when I used to write legislation as a youngster, I was appalled to discover that I wasn't supposed to specify everything logically. Sometimes the state of play when it was time for a floor vote, or at other times at markup, was that there were things that weren't yet negotiated, and the decision at political levels and mature levels was we're going to be deliberately ambiguous in some cases because we want to get this legislation passed. Same thing in contracts. So I think we have layers to unravel with, now like worn, barnacle-ridden, crusty processes to refactor the law so it can be computable and serve its purposes. We're going to have to also do some fresh thinking. We have another question. Why don't you come forward?
So, I think that's an incredible point, right? Once again, sorry, I'll keep it short. That's a great point, Taza, and that you have to reformat the law, and your points are so brilliant. I love listening to you. It inspires so much hope. But then when I hear something like, you just spoke with the legal representative from New South Wales, like, so I ran PayPal Australia's products.
Yeah.
And I was in charge of the enforceable undertaking where Australia sued PayPal for not applying specifically AML, KYC, CTF, anti-money laundering, counterterrorism financing, and know your customer compliance laws. We violated those laws in their eyes, even though in the reality of the law, we did not. And so, like, when you think about like that kind of meta, and when you think about the kind of germane abstraction of precision, so how do you actually resolve that conflict? And more kind of precisely, any sort of adoption requires acceleration of adoption, right? That's the J curve is the story of Silicon Valley. So who's your customer, and who are you accelerating? Because if it's the end user, it's pretty meta, and if it's the law, it's pretty physical. So who's your customer?
Thank you.
Yeah, that's an interesting question. I think that it's the legal ecosystem. We're improving the legal ecosystem. I think there are many end users. The first order of business is to make the law, in this context, is to make the law computable. And then you say you complied with the law. The government said you did not comply with the law.
Literally.
Right. if there is some sort of machine consumable legislation where you could in some way say, listen, we've complied with all of this, there's some sort of real-time checking where the people who interact with the code and the people who write the code both agree the code is the code, then you can say the system says we're okay, and then the government can't enforce it against you. At the same rate, if you go off the rails, then they can say you're off. But in this case, both people trust the system. The problem with ambiguity in the law, which is the pseudocode issue, or the does it issue, is there is room for this dispute. In fact, many times you get the bill passed, and then you say the court will resolve it. Maybe it'll be 20 years from now, but my constituents will be happy. I feel like I won't fall on any sort of sword for this sort of thing. Yeah.
A quick addition, if I may. It is a perfectly acceptable step in a well-specified computational process to say, ask the human in the robe on this one. That is a perfectly acceptable step, and I think you're going to find that as you automate law, you're going to hit those pockets where you're going to say, we didn't decide, we presumed the human in the robe would go ask the human in the robe. The other piece of it is that this ambiguity is often around feature extraction problems, and those are all over the computational world when you're trying to extract some kind of feature from the mess of reality. So again, the law is going to bump against these, but we have techniques for dealing with them. We have, and there's no reason to think those techniques can't continue.
Sure. Wisdom law. We have another question.
Thank you very much. Sitting in this conversation for about half an hour, I get this feeling of kind of very philosophical discussion of many things. And while that may be all there's so much emphasis on inventing technology, like she also mentioned. I almost got the feeling that you're saying that you need to invent new technology to get all these disparate databases of all these hundreds of thousands of lawyers online, out there online, and we need to invent technology. But I think that that's not correct because there's so much technology and so much working, and SEC, other people are already doing this.
I agree.
While the problem we fail to see is that it is an adaptation problem, which is again a very wide thing. It's a reward problem. It's a customer orientation problem. The whole problem here, the whole scale that we want to achieve to make it, viable for people outside this 1% niche market of the blockchain community is what kind of reward structure I'm offering, what kind of cool user interface I'm offering, what kind of a incentive system are you, this discussion is bereft of that aspect completely. So I don't think that's useful. Thank you.
Okay, let's unbereft it. Thoughts, ideas, wisdom.
Well, yeah, I agree. I think that there is a huge interface problem. So the reason why it's expensive to use lawyers now because everything is done manually. They think manually and they charge you manually for the time, and you pay for the cost of input, not output, which is ridiculous for most industries. But lawyers still do that. But I do agree that the technology exists, and we've been writing code for ages, and we've been designing language for ages. But there are some domains like graphics design, which require PostScript, or Autodesk, which there's a proprietary standard for architectural designs that you need to express certain very niche concepts in programming languages or in a programming language to be able to express that, so that you can get from the syntax, which is what does it mean, to the semantics, to what does it say, to the semantics of what does it mean, and to the pragmatics of what does it mean for me, which is really what the end users care about. And you're spot on that it is, there are a lot of technologies available, but how do you bridge the gap between the technology and end users? And I think that's an interface problem. So I don't need to know what aperture means or focal length and all of those things, but I understand what a filter means on Instagram. Sorry, I don't actually use Instagram, so I'm just using that as an example. But you can Instagramify law. So the technologies and building law with a programming language that is specifically designed for that allows you to do that once and very efficiently and scale that so it's cheap, so that people can run tests and ask questions of your laws, of your contracts via an interface without having to go to law school, which frankly is a language immersion program where you learn to talk to other lawyers. So so that's my answer.
We have one last question from the audience. Any other answers to the last question on the panel? Hearing none. Sir.
I think actually part of it is there's a logical fallacy and a lack of deep knowledge about how actually systems, not just software, is written. So structurally, the logical fallacy is that everything's going to be programming software code. It's not. Half of the things that you're implementing and you enforce as a protection are things like algorithms. You know, it's things like algorithmic trading. You have contracts that are literally enforced by code, and they move at the speed of light right now, even before AIs started as hedge funds. So actually, if we look at these other elements that are outside of the baseline of software programming, webware, AI, database, auto transactions, computer transactions, there are models you can do that, but one of the problems is, where's the actual compelling value proposition the other gentleman talked about? To build scale, so people will take the risk to change things. I mean, there's some projects, law labs, law firms are funding it, people are trying it. Where will they take the risk, like the big insurance companies, to auto-buy when they get data about weather that tells them they have to for the actual big agro companies? Because that's the part you have to get them to do, to take the risk of letting an AI or computer auto hard code commands and legal enforcement. There's one model I think you should look at. We were just at an event last week with the EU. Ireland, because they have such an interesting regulatory environment now with Brexit coming up and a lot of data centers, they're looking at giving and rolling in the enforcement where they physically send inspectors inside of companies real time. They call them embedded, that's actually a model where people can combine with technologies to enforce in the future.
Thank you. Okay, discuss.
This is, I think, part of the point that Dawes was making about extended intelligence. That we are unlikely to automate every aspect of legal process. Even in a highly automated DAO of some kind, there will be many ask the humans in the DAO questions. So what we hope for is a system in which the technology can take over the things it will do well and leave to the humans the things they'll do well. And that's a bit of a utopian hope, but with any luck we can at least get partway down the road and do a reasonable job.
One thing I would like to say about that is probably we need to change the lawyers. It's very much a question of legal education and what you teach them in the long term. If you change the lawyers, in the end you will also change the regulators, and you will get your law computational if that's what you taught them at law school.
And the only thing I can add to that is that that's the whole purpose of Legal Hackers. That's the whole purpose of this community and communities around the world, is to create this open culture for law where we're all discussing these issues, we're all moving forward on them, addressing the really, really hard questions and trying to come up with creative solutions.
Yeah, and also like spreadsheets, took 20 years to take hold, but then, to an accounting software, but you wouldn't think someone was a decent accountant today if they told you that, oh, I'm just really good at math and I can count, but I don't use these things because, that's just for kids and that's just toy. So I think lawyers of tomorrow, the future lawyers, will be quite different from the lawyers today, and I think you make a great point about how the lawyers and the practice of law will change quite different. It's not going to replace the profession, but the industry will be quite different. Sorry, I don't have a point to make. Oh, I think that was so two other points. The first point is that there's a difference between ambiguity and vagueness, and computer scientists have a very clear idea of this. And lawyers like to say that, we inbuilt ambiguity into the contract as if it's really cool, but that's not actually what they mean. What they actually mean is vagueness, where no one knows what it means. And ambiguity means, well, we know exactly what the parameters are, and we just agree that these aren't agreed on, or we'll defer it to a future time, but you know exactly what the known unknowns are, which is very different from, well, no one knows what the hell is going on, and maybe at some point, if shit really hits the fan, we'll decide in court, which is not great. And the third point is that when we talk about AI, it's very tempting to use the more invoked meaning of AI today to mean statistical AI, which is, and I didn't come up with this, I saw this on Twitter, but I can't remember who said it, but the difference between statistical AI and symbolic AI, which is the other camp that is often overlooked, is that, your parents say, if all your friends jump off a bridge, would you do it? Statistical AI says, yeah, because all my friends jumped off a bridge. And symbolic AI, is AI that you can reason with. So it wouldn't say, yes, I would jump off the bridge because everyone else did it. It would say, well, if I'm optimizing for not jumping off the bridge and I'm not dying, then I wouldn't do it. And the fact that my friends all jumped off is completely irrelevant. So you want to move, when we talk about computer contracts and computational law, we want to move it to a realm where you have AI and algorithms that you can argue with. And I think that's where the human parts come in.
And then, a lawyer would hasten to add, well, what if you were with all your friends and it was like a bungee thing on the bridge? What if the bridge was on fire? What if you were on and on? It's all context. It's all context.
It depends.
You come back to it depends. However, now finally, with the power of computation and the skill that we've acquired as a species, we can begin to define all of the factors upon which it depends and bring them into the system so that we can have more agency to shape the law to govern the world that we would seek to inhabit. And that really is what Legal Hackers is about. That's what this festival is about. You've all been terrific, and that wraps up our panel.
Hey, thank you.